one might describe it as the individual right to be relatively free of government intervention into your life. Whereas civil rights, sometimes referred to as equal rights, is an individual right not to be treated differently because of the group you're in. Now, both of these are carried out really on the level of the individual. They're not about group rights or anything like that. They're about individual rights. Now, with civil liberties, the framework is the habeas corpus part of the Constitution, which is in Article 1, Section 9, and the Bill of Rights, the 1 through 9 amendments, and some state constitutions and state laws. But for the most part, we're talking about the Bill of Rights. The idea of civil liberties is most compatible with the idea of a relatively limited government, because we're talking about government intervention in your life, restricting you in certain ways. But it's clear that government is also often the medium through which we challenge government restrictions on freedoms. Now, civil rights, the individual right not to be treated differently because of the group one is in, we're talking primarily about the 14th Amendment to the Constitution and federal laws, including the Civil Rights Act of 1964, the Equal Pay Act of 1963, other ones like the Pregnancy Non-Discrimination Act, the Americans with Disabilities Act, and also many state laws like those that prohibit sexual orientation discrimination. And we've already talked about this a little bit with civil rights. This notion has more affinity with the idea of an active government, because often government is making sure its own actions are fair, or they're making sure private actions treat people the same. All right, but we're going to focus here on civil liberties. Now, the first, again, about civil liberties, the first thing to talk about is that the civil liberties protections that one finds in the Bill of Rights, like the First Amendment, Congress shall make no law respecting the establishment of religion or abridging the freedom of speech. When this was put into the Constitution, it was meant to apply to the federal government. The Bill of Rights was put in by people who said, we were not going to agree to this new federal government unless you limit its powers with a Bill of Rights. And so that's why the structure of this First Amendment is focused on Congress. It says, Congress shall make no law. And for the first more than 100 years, that's what it meant. It meant Congress shall make no law. But as time passed, people started to get a little more worried about state governments and wondering at what point are state governments restricted by the Bill of Rights. And by state governments, we also mean the city police, right? Up until this time in 1926, this was not applied to city governments. City governments could restrict the freedom of speech without having to worry about the First Amendment. This changes, first, I'm going to move down here to this one real fast, in a case called Gitlow versus New York in 1926. And what had happened in that case, this guy named Benjamin Gitlow had made a speech essentially kind of advocating the overthrow of the government. And he had been arrested by officers in New York and prosecuted, found guilty. And his lawyer made a kind of an interesting argument, which had not been accepted by the court before this. And that was that his First Amendment rights were violated by a law that punished speech. Now, the way that they made that argument, the way that the lawyer made that argument was to refer back to the 14th Amendment. All right, now the 14th Amendment, remember, was put in the Constitution in 1868, and it's put in the Constitution after the Civil War, of course, to protect the rights of former slaves. And it says, no state shall, and for this purpose, the most important provisions are this one right here. No state shall deprive any person of life, liberty, or property without due process of law. And what the lawyer for Benjamin Gitlow argued was that the liberty that was protected against state violation by the 14th Amendment, that one liberty that was protected was the liberty of speech in the First Amendment. Now, this was an interpretation. There's no indication anywhere in the record that when they put this in 1868 that they meant the First Amendment when they put this word liberty in there, and that they were thinking at that time of this particular issue. But in 1926, the court accepted that argument and said, well, okay, the 14th Amendment does guarantee liberty against state infringement, and so we're going to say that instead of the First Amendment meaning this anymore, now it's going to mean this. Congress and the states shall make no law abridging the freedom of speech. Now, this is an interpretation, and it saved us from having to amend the Constitution to write something like this in. And it begins what turns out to be a fairly long process of scrutinizing each of the freedoms or liberties that are in the Bill of Rights to see if states should be bound by them. Now, I just want to mention, just give you a local example of this. There's a historian over at City College who's done a lot of work on what was essentially a free speech movement in San Diego in 1911, 1912 period. And there were union organizers in the city trying to organize workers, and they were punished under a city ordinance that said that you couldn't make speeches about such things. And so every time they would sort of stand up to make a speech, they would be hauled off to jail because the city of San Diego was not bound by the First Amendment during that period. That doesn't start to happen until 1926. So just to give you an example. Now, the process of what we call selective incorporation, and that is the long process of incorporating on a selective basis different parts of the Bill of Rights to be enforceable against the states. The first step in that, of course, is Gitlow versus New York, 1926. In a case of just a few years later, the court recognizes that the right to free press is also a right that has to be respected by the states. In 1937, Assembly is incorporated. The religion provisions of the First Amendment are incorporated in several cases in the 1930s and 1940s. And by the way, you'll find in your textbook a list of all these cases in one of those blue boxes in Chapter 4. And then there's a bit of a hiatus for a couple of decades, and then in 1961, they begin to focus on the 4th through the 8th Amendments. The first is the provision against unreasonable search and seizure that you find in the 4th Amendment in a case called Mapp versus Ohio. For the first time, that is made enforceable against the state governments. And of course, this is very important because chances are, if you are arrested by an officer of a government, it's not going to be a federal officer. It's going to be a local police department or a state police officer. And so the fact that these are now going to be insured against violation by the state and by the cities, this is really important. So various provisions of the 4th through the 8th Amendments incorporated 1960s and 1970s. the very last provision to be incorporated is the Second Amendment, the right to bear arms, and that was incorporated in a case in 2010. And in that case in 2010, the prior case in 2008 found that the Supreme Court found that there was an individual right to own a firearm, and that was the first time the court had held that. That was in 2008. And then in 2010, Scalia writes a decision saying that the state governments are bound by this interpretation of the Second Amendment. There are several provisions of the Bill of Rights that have never been incorporated. So, for instance, in the Seventh Amendment, you'll find a provision that says that in a case where the money that's at stake is worth more than $20, that one is entitled to a jury trial. Now, this has not been incorporated against the state governments. And you're saying, well, why not? Well, it's because it would essentially bankrupt the state governments if they had to provide a jury trial every time someone charged that they were owed damages of $30 or something like that. In the federal cases, you do have a right to a jury trial if it's worth more than $20, but not in the states. And so they're kind of picky about which provisions they incorporate. They take a pragmatic stance to this. If it doesn't make sense, they're not going to incorporate them. All right, so selective incorporation. Now what I want to do, the last thing that I want to briefly do is just add a little bit more about press freedom in the First Amendment and about the Fourth Amendment, okay? The First Amendment also includes the freedom of the press, and the way that the court has understood that in the past is in terms of what they call no prior restraint. So the idea is that it is not okay for the government to establish a rule that says if you publish this document, you will automatically be subject to prosecution. If you are a press, if you are a member of the press and you publish this kind of document, that you would be subject to prosecution. Now, obviously what we're talking about here is classified documents for the most part, right? And what had happened is in the in the 1960s and 70s, when we were involved in the Vietnam War, the Army had produced a series of reports about the war and about the progress of the war, saying, oh, it's terrible, I don't know how long it's going to take to get out of here, it's a big mess. And they had classified these reports, and at the same time the political officials were saying, everything's fine, don't worry about it, we'll be out of there, it's going all right. Now, along comes a guy who finds out about these reports. He makes a copy and is trying to get them published. They're classified documents. He steals them. He's trying to get them published. So one of the newspapers that he gives them to is the New York Times. And the New York Times wants to publish these things, but they were a little worried about publishing them. So they produce a story and they tell the federal government, this is the story we're going to publish. And the federal government says, you must not publish those things, and sues the New York Times to have an injunction against their publishing them. And this case makes its way to the Supreme Court. Now, the Supreme Court's pretty divided on this question, but what they ultimately end up saying is that the idea that a government can say and be the ones to decide what is classified and what isn't is sort of leaving, the fox to guard the hen house, in a sense. So if you leave it up to the government to say these things cannot be published on pain of going to jail, then one would suspect that there's going to be a great temptation for the government to classify anything that's going to make them look bad. And they're going to be the ones to decide what's classified and what's not. And so what the court was doing essentially is taking that issue out of the hands of the government and putting it in the hands of the press, and saying that you cannot restrict the press from publishing things that they think that the public should know, because it's precisely those things that are classified that in many cases the public really needs to know. Now they left they made another point, and that was that if the press does publish something that leads to damage of some sort, like let's say they publish the identity of an undercover agent and that person turns up dead, they left room for prosecuting the press in that case for being irresponsible with national security. So it was an enormous responsibility that that they placed in the lap of the press with this 1972 case. And so the rule of no prior restraint is what is kind of governing this issue still today. And we can think of a couple of recent examples. Of course, the issue of WikiLeaks, and Chelsea Manning, or used to be Bradley Manning, stole all of those hundreds of thousands of State Department memos and turned them over to Julian Assange, who just kind of put them out there on WikiLeaks. That's one issue. Chelsea Manning is in jail right now. So this idea does not make it permissible to steal classified documents. If you steal a classified document, you can be prosecuted. What it does is it shields the press that publishes them. And of course we have the case of Edward Snowden. And Edward Snowden stole many, many classified documents and turned them over to press outlets like the New York Times and fled the country. If he were, he has certainly been threatened with prosecution if he were to be captured or come back here. There was just a couple days over the last couple of days, some very prominent citizens calling for him to be pardoned by the president before President Obama leaves office. So it's a big controversy about is Snowden a whistleblower to be celebrated, or is he a traitor who would disclose important secrets? It's a big debate. Now, let me just turn very quickly to the Fourth Amendment. The Fourth Amendment includes two important phrases: the right of the people to be free in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated. So, no unreasonable search and seizure. And no warrant shall issue but on probable cause. So if you're going to search, you need a warrant with probable cause, and that means court oversight. Now, there are limits. The way we understand this, the court is constantly, almost every term, there'll be one or two cases about, is this reasonable? Is this an unreasonable search or a reasonable search? Remember I mentioned heat-seeking cameras, for instance. The court determined that those were unreasonable searches, but technology moves ahead, and every time there's a new technology used to search people, question makes its way to the Supreme Court: is that reasonable or unreasonable? And so we have a list of Supreme Court cases that filter their way down to the court, down to the police departments, about what's acceptable and what's not. And of course the warrant requirement is not 100%. So if the police officers are following somebody that they're pretty sure just killed somebody, and that person runs into a house, they don't need to go and request a warrant in order to go into the house. So, there's certain kinds of situations in which that the court has said it's understandable that you would search without a warrant. And there's a list in your textbook of also how automobiles, for instance, are treated differently than houses are. I'm not going to go through that whole list. It changes, you know, like I said, almost every term, almost every court term. But, you know, understanding the way these things, the way the court understands these things is crucial in understanding your rights if the court does kind of show up on your doorstep. Now, in implementing this, the court in 1961 established what was called the exclusionary rule in the case Matt versus Ohio. And the exclusionary rule is the rule that says that if a police department does acquire any evidence through a search that's unreasonable or without a warrant, that information and all information that follows it has to be excluded from court. I want to mention this. I mean, it's important to understand this, but also it's important it helps to understand the way our separate powers work in our system. The police departments are in which branch? Let's think for a second. The police departments are in the executive branch of government, right? And the courts obviously are in the judicial branch. Now, under our separation of power system, the judicial branch does not have any direct jurisdiction over the executive branch. They can't directly tell the executive branch what to do. They can't fine the executive branch. They don't have any powers like that. What they do have power over is the court, which is on their side of the fence, right? And so if the police departments find information or evidence in a way that the court has said is unacceptable, they can still go about and do those things, right? But if it arrives in the court will throw it out. And that changes police department behavior just by that act, because if a police department uses a heat-seeking camera, they decide they're going to get a warrant to search a particular house. They search that house. They find a massive drug ring. They do 5 years of investigation of all the different people involved in this drug ring, and then they arrive in court 6 years later, and the court finds out that the original piece of information came from a heat-seeking camera after they had said heat-seeking camera was not okay. 6 years of work is thrown out the door. And so that changes police behavior. So that's how we get the feedback between the courts and the police departments. So that's mostly what I want to discuss with civil liberties. I want to